Welcome, everyone. Today, we are going to take a look at a recent decision from the UK, which is particularly interesting because the court in this ruling defined the terms of a global front license that the parties of the proceedings should sign. And in the course of that, the court also provided some findings on related topics, for example, the issue of hold up and hold out and how to treat this, or how parties should behave in negotiations. So a lot of topics which are particularly interesting and relevant for us. The case is a dispute between Optis as the claimant and Apple on the defendant side. The decision is from the High Court of Justice and was delivered on the 10th of May this year. Now, if we take a look at some background of this case, it is clear that this was not the first decision rendered in this dispute. We have also seen in our webinars here several decisions also in the past. This whole case started in early 2017. Then the parties had the first discussions, initially focusing on an NDA. And after that, there were exchange of emails regarding potential rates and the potential license agreement. A first offer was made by Optis in December 2017, which Apple did not accept, and instead it made a counter offer in April 2018, which was, however, relatively different from the offer that Optis made. So again, there was no agreement. These proceedings were initiated then in February 2019. Optis filed the lawsuit in the UK and asserted, I think, 8 patents, UK patents in total against Apple before the High Court. Regarding the negotiations up to that point in time, there have been several emails exchanged, etc. We cannot really go into the details. Maybe a couple of elements which are interesting and also were taken into account by the court. One element regarding Optis was that much of the communications was made orally and not documented very well. And since the court relied more on documentary evidence here in the present case, it tended to see an asymmetry regarding the two cases of the two parties here. For example, Optis had claimed that there had been two offers made to Apple, one in March 2017 and another one in August 2017, but the court found not enough evidence that these were actual offers and not just talking about terms more generally. What, on the other hand, can be said about Apple is that a general theme throughout the negotiations was that they insisted on their own FRAND framework for licensing negotiations, which is based on specific assumptions. For example, they want to have prefer a lump sum payment. They rely on the SSPPU for the royalty calculation, or they require a patent by patent assessment of the portfolio. So these were elements which Apple insisted on during the negotiations as well. So this is just a very brief overview of what happened and of the elements which the court found more decisive in its decision going forward. Now, looking at the proceedings here, we had the very typical case as we have in UK litigation, that the court split the proceedings in different trials. There were technical trials, 4 technical trials, which dealt with the validity and the essentiality of the patents that have been asserted. And there was another trial which would deal with the issue of injunctive relief, whether an injunction should be available to Optis in the present case and under which conditions. And the final trial would be the FRAND trial, so the one in which the terms of a FRAND license would be determined. Looking historically, the first decisions that were rendered were on technical trials. So the first one was in October 2020. The court confirmed infringement of the one patent in the first technical trial A. Then there was a decision in June 2021 on the second technical trial. There the patent was found valid and essential as well. The important decision was in September 2021, where the court established the requirements for granting an injunction to Optis in the present case. And very generally, it said that an injunction would be granted, as we had already the establishment of infringement previously in these proceedings, unless Apple would commit to to accept the terms that the court would determine as FRAND. Apple appealed this decision, but nevertheless, it made this commitment shortly after this decision was rendered to accept the court-determined licensing terms. This notion or this approach was also confirmed by the Court of Appeal in October 2022. In the meantime, there were also decisions on the technical trials. There were decisions both on of first instance on validity and essentiality, and also some appeal decisions on validity and essentiality. What was the outcome until now was that in one case, there was one patent that was found to be valid but not essential. In another of the trials, the patent was found valid and essential. And in another trial, there was also a similar finding of validity and essentiality of 3 patents that were asserted. And the last one is pending in the appeal stage now. In the first instance, there was again a finding that 3 patents asserted were valid and essential. So this is something that is ongoing. The appeal is ongoing on this topic. But in the meantime, in the 10th of May last year, the court also delivered its ruling in the FRAND trial, and this is the decision we're discussing today. I think before we start with the legal part, it's good to take a look at what the court determined here as the licensing terms that are found in the specific case. This is a summary of these elements which the court found to be FRAND here. Starting with the scope, the court requested or found that a worldwide license should be signed, a 4G multi-standard license, meaning covering 4G, 2G, and 3G. Regarding 5G, it was not clear whether it should be included or not, so this is something still to be discussed. But what is clear is that the license should cover all products of Apple, meaning both existing products and future products. Regarding the term, the court found that the license should exist until the expiry of the longest living portfolio patent. And then the royalty that should be paid, the court preferred a lump sum payment here and an annual lump sum payment, and determined that this payment should be one of 5.13 million US dollars. And it also found that Apple should pay 5-year annual rate upfront without any discount. This is something that concerns the future. The court had, however, also a provision about past sales, past release. There, the court found that Apple should pay a release for 6 years, starting with 2017, when parties started the discussions. And what was interesting here, the release should be the same lump sum amount annually as for future payments. So this 5.13 million euros a year, dollars a year, I'm sorry. The court also said that for past sales, there should also be interest paid by Apple, and it said that interest should amount to 5% per year. But this is not the final view of the court here. This is a provisional view. The court wanted to leave this open for discussion. If this is going to be 5%, that meaning the amount that interest is payable, this is something that is final. And then a final provision regarding pending litigation. If the license agreement is signed, then all pending proceedings globally between the parties must cease. So this is the license terms which the court determined. And now we're going to take a look at how the court reached this result here. Of course, in the focus of the court in this decision was the FRAND calculation, how to calculate royalty rates that are FRAND, how to calculate licensing terms that are FRAND. And before going into the details, the court made some general remarks here, particularly looking at how to determine a FRAND price. What is a FRAND price? The court noted here that the FRAND price is not a market price, meaning that there is no market from which you can derive prices for SEPs that are declared to a standard. What you need, therefore, to do is to take reference to factors that proxy a market price. And in the eyes of the court, this is typically comparable transactions. Now, in the SEP context, these are usually comparable license agreements. And the court said this is something that should apply also in the SEP context, but it found some difficulties for finding comparable transactions in the SEP context. Looking at comparable agreements, it found that unpacking of comparable licenses can be difficult and very complex, and also include some subjective elements that is not something that is good. We're going to see more of that in a moment. And it also noted that the portfolios in the SEP context are unique, meaning that if you're looking at comparable transactions, you cannot really compare what other sellers charge in the market for the same product, exactly because only one SEP owner has this product, which is the portfolio. So these were some general remarks of the court on how to deal with comparable transactions or comparable agreements in this context. In any case, what the court found was that FRAND, of course, needs to be formed by the values that make out FRAND, which is fair, reasonable, and non-discriminatory. And we're going to see in a moment how the court interpreted that in the present case. Before that, just a few words on the comparables, because this was something which the court discussed a lot in these proceedings, not much from the principle side, but more looking at the specific comparables that were produced in the proceedings and the evidence that was produced by the parties in the proceedings. So in general terms, the court did not really contest that the comparables are something that is of significant evidential value and should be looked at when you're trying to do a determination of FRAND terms or FRAND price. In the specific case, however, the comparables produced by the parties should be treated with extreme caution, according to the court here. So the court was not really satisfied by the way the parties dealt with the comparables in the present case. And there were two elements which the court found difficult. The first one was that the comparables that were produced by Optis and by Apple were categorically different, as the court put it here. Why was that? Because there were two different pools, basically, of comparable agreements, which had no real overlap. So Optis presented agreements for its own portfolio that it had signed with third-party licensees, and usually had an ad valorem rate. This is the term that the court used, meaning that the rate was calculated based on a percentage of the selling price. On the other hand, Apple produced licenses it had signed as a licensee with a third SEP holders, and usually these were a lump sum licenses. So these were two different pools of licenses, basically, that the parties relied upon in the proceedings. And this was one part of the problem. The other part of the problem was that the unpacking of these licenses was done differently by the experts which the parties had used in the proceedings. So the court found no common ground here regarding the evidence that the parties produced, and found that there are subjectivities and assumptions applied regarding, for example, how to unpack different rates, how to value cross licenses, or how to deal with future royalties and past releases, especially in lump sum payments, how to differentiate that and unpack that. So there were different ways in which the parties did that. So in overall terms, the evidence that the parties produced based on the comparable agreements was not found to be reliable by the court. Nevertheless, we're going to see in a moment the court used comparables, the comparables of presented by the parties. However, tried to, let's say, extract its own results out of these agreements. It did not rely on what the party said about these agreements. Now, looking at the FRAND price, the court said it's should be fair, reasonable, and non-discriminatory. And it made here some remarks of how to understand this. And it started with a non-discriminatory element. So what is a non-discriminatory price? And it said that in principle, it is a price where you have no differentiation in a discriminatory way, both between SEP owners and implementers. So here the court said, respecting all material differences which might be there between SEP owners, for example, different sizes of portfolios that they have, or between implementers, different products that they sell, sales volumes, for example, or prices that they sell their prices, their products in the market. What a non-discriminatory means is that the implementers ought to pay the same and the SEP owners ought to be paid the same. Again, respecting all material differences that might exist between implementers or between SEP owners. More in detail, what does this mean? If you look at non-discrimination between implementers, this will usually mean that you need a more flexible approach than a one-size-fits-all approach. So the court said here, if you look at how not to discriminate between implementers, it's hardly thinkable that you will do that by offering them basically all the same deal. This is something that needs to be more flexible. And it made some presented some thoughts there. It said, for example, if you use the same ad valorem rate, again, this is a percentage of the selling price to calculate the royalty. This can be problematic when the product's prices vary significantly. If you use the same per unit rate for everyone, this could be also problematic when sales volumes differ significantly. And using the same lump sum payment will, as a rule, be discriminatory because then everyone has to pay the same lump sum. This is something which cannot be non-discriminatory usually. Having said that, it also looked what does non-discrimination mean between SEP owners. And this means in the eyes of the court basically that the price which its SEP owner charges must vary as to the proportion of the stack of patents owned by each SEP owner. This means, in other words, so that every SEP owner gets basically paid the same. It means that it must be paid based on how much is its share in the overall number of SEPs which are relevant for a standard. The court said here, in this respect, quality, meaning, for example, whether the patents in the portfolio are valid, are essential, or are important on technical merits for a specific standard, is something that should not play a role in this regard, because at the end of the day, the implementer does not pay for valid, essential, and important SEPs, but for access to the standard. So here, the court is basically saying is favoring more, let's say, counting patents, and in order to see what is the share of the patent holder in the overall ecosystem of SEPs, rather than looking at let's say qualitative issues that we're going to see in a moment, that the court followed this line also in other respects. So non-discriminatory, we have seen what the court means with that. And then the court also wanted to define what is fair and reasonable. What is a fair and reasonable price? And here it looked at these terms, and it's found that they're hard to define if you basically try to define them as without context. And therefore it tried to find an analogy what you could use as something similar as orientation of what is fair and reasonable in the SEP context. And it found that an analogy could be drawn to excessive pricing in abuse of dominance cases. Now, the court said there is a very close alignment between a price which is above FRAND and an excessive price, although they don't match 100%. So there is a gap. You can have a super FRAND price which is not excessive, but nevertheless they are closely aligned in the eyes of the court. And that means that for considering what is fair and reasonable, you can look at comparables again, which was one of the best sources in the eyes of the court, or costs or prices charged by others for agreements that are not directly comparable. What should be the principle here is that the FRAND price must consider the value of the standard to the implementer. So this is what the court believed to be fair and reasonable. What you need to value is the access to the standards, because the court said this is what the implementer is paying for at the end of the day. How you value this access to the standard and the value to the implementer can be done with different royalties, different royalty rates. So the court did not say basically you have to always choose a lump sum rate or a per unit rate. You can pick one of the available rates. But the principle again is that you need to focus on the value of the standard to the implementer. And looking at the question how to do that, how to value how to price the value of the standard or specific SAP portfolio as part of the standard to the implementer, the court said you can look at the profit that can be made by using the standard in the products, the profit for the implementer. This can be an important element. What should not be taken into account, on the other hand, is the value of the connectivity to the end consumer. So the one who buys, let's say, the handsets. This is something which the court found not relevant because the focus should be made on what the implementer gets from using the standard in its products and the profit that it makes. The value of the connectivity to the consumer was something which the court found is also very hard to determine, since connectivity, if you look at handsets, for example, is something that is applicable everywhere and adds value to every feature of a phone. So the court found this is something also difficult to calculate here. Now we have seen the principles which the court set up in order to determine what is a FRAND price. And now let's take a look at the concrete methodology that the court used. And here, I think it's pretty simple. If you look thinking of the court's first said what you need to do is to price the value of the entire stack of SEPs, meaning all SEPs that have been that are relevant for the standards here for April. So this is the first thing you need to do. Put a price tag on the entire stack of SEPs that are relevant here for April. And when we have done that, the second step is to apportion a price pro rata between the owners of the different portfolios based on in proportion to their holdings, basically to their portfolios, to the strength of their portfolio. So these are the two steps which the court used here in order to come to a specific price for Optis portfolio. And we're going to take a look at these two steps more closely now. The first step is to value the stack of patents that are relevant. And the first question here, of course, before going into valuation is, what is the stack? So what should be considered in the stack? And this was an issue where the court found surprisingly significant evidential deficiencies regarding the data that it has concerning the stack. So what are the SEPs, basically? What are the standard essential patents for relevant for the standards? The parties did not rely on the EWHC database, and the court understood that this was something okay, because it also saw that there is there is a risk of over-declaration, which is enormous and largely uncontrolled by ETSI. It did not criticize the way ETSI has set up the database. It found that over-declaration is an attribute inherent to the system, and it also found that putting filters in the ETSI database would be likely counterproductive. But for evidential purposes, it was not. It followed basically the view of the parties here that you cannot extract relevant data on the stack from the ETSI database. So what could be another source of information, data produced by third parties, by consultancies here? The parties had produced such data. Apple had produced data by a company called Innography, and it had also, in the alternative, relied on data by another consultancy, the PA Consulting. Optis had some evidence by an own witness, Mrs. Dwyer, which was, however, abandoned during the course of the proceedings, and then it relied more on the PA Consulting data. And looking at this data and the criticisms that the parties mutually had expressed on this data, the court found that this third-party data needs to be used with some caution. So again, the court was not convinced that it was something which really brings evidence in these questions here. It criticized the fact that the parties had not brought anyone either from Innography nor from PA Consulting in the proceedings to give evidence. So the evidence on the quality of the data was rather patchy in the eyes of the court. And also an indication that the data needed to be used with some caution was the fact that the parties had changed views regarding the quality of the data over the course of the trial. So initially, Apple was a bit supportive of PA Consulting data. Then after Optis started also relying on PA Consulting data, Apple started criticizing this data. So all of these changes in the way the parties presented the data and presented also the quality of the data brought some confusion to the court, so that it had some reservations of how to use the data, and it used it with caution indeed. Now, it had, of course, to take a decision here. So which data to prefer? And there were basically these two choices, the data from Innography, which was a purely quantitative data, meaning that it was data only on declarations. And there was the data of PA Consulting, which had declarations included, but it had also a qualitative assessment, or meaning that it had assessed also essentiality of a part of the patents. And between these two, in the present case, although the court found, of course, that it is preferable to have data over the stack of actually essential patents, it preferred to rely only on the declaration data, which does not have any such assessment, because it said using this quantitative data is better than using unreliable data with a qualitative assessment. And where it saw a problem with data not only focusing on declaration, but also adding, let's say, essentiality to that, was that the assessment of levels of essentiality is unreliable and unsafe in the eyes of the court, because it can have subjectivities. And at the end of the day, whether a patent is essential or not is something where the courts have the last word. So any assessment of essentiality which does not basically come from a court is unreliable and unsafe. So the court therefore preferred to focus on the pure numbers of declarations, basically, where you don't have these qualitative elements included, which might produce this type of questions and make the data unreliable. So at the end of the day, the stack which the court considered are the declared patent families for the standards that were included here. Now that the court determined the stack, the question was how to value the stack for April precisely. And here the court took two different scenarios. So one was to calculate at an ad valorem rate, meaning a rate as a percentage of the average selling price, and to calculate a lump sum rate. This what the court did basically was to extrapolate from the comparables produced by the parties a rate, and then see if this is something reasonable or not. And having done that both on both bases, so also on an ad valorem basis and on a lump sum basis, it found that the ad valorem rate was unreliable and certainly not FRAND, meaning also because it was too high in the eyes of the court here. This calculation was based on comparable agreements that Optis had produced, because they were most of them had an ad valorem regime agreed with the licensees. On the other hand, the April comparables were not really used much in this assessment because they were most of them lump sum licenses, and the court found that the unpacking of this would introduce again subjectivities here. But looking at the comparables that Optis had produced, it found that they were worse than useless for deriving a price for April. And the main reason for that was that these licenses were with parties which were not equal to Apple, so with licensees which were not companies of the size of Apple, or close to the size of Apple. So the court also said here it had the impression that these licenses were signed without having a real economic significance for Optis, but just to get comparable rates, which then could be used for future licenses. So that's why the court was very critical about this type of calculation here of valuing the stack based on this ad valorem basis, and preferred to have a lump sum rate calculated. Generally, the court said, well, lump sum rates could be generally preferable because what the bottom line for the licensor and the licensee is always a monetary bottom line. So you need to have basically a price, and that's what parties are more interested for. And more precisely, in the present case here, it preferred also a lump sum rate because the evidence supporting a lump sum rate were seen as more reliable. What were the key difference here? It used the Apple comparable agreements, which were most of them a lump sum licenses. So they did not require unpacking, and you did not have, let's say, this subjectivity. You could compare them more easily. What the court also found important here was that the comparables of Apple concerned different parts of the stack, as they were signed with different SEP holders. So let's say they allow a more broader view on the overall SEP landscape, whereas the licenses of Optis referred only to the Optis portfolio, which is, as the court found here, a relatively small part of the overall SEP landscape. And then also an important element here was that the licensors were big beasts, as the court said here, meaning rather larger companies with significant shares of SEPs with large portfolios. So this would give a better impression of the value of the overall stack than the licenses of Optis, which again referred to a share on the overall landscape, SEP landscape, which was very small beer, as the court put it here. So this was then the court's decision here. It determined this lump sum rate for the overall stack. And then it went on to the next step, which was to make this apportionment. So to determine the specific share of Optis within this overall price for the stack. And here again, the court calculated Optis's share based on quantitative data. Again, declared patent families. it did not use, again, qualitative elements as to essentiality, for example, because, again, the same reason was that they were considered unreliable because they have subjective elements in the assessment. One interesting point here was the fact that Optis had argued that you cannot really look just at the numbers. You should give a higher price to Optis portfolio, or that there is a higher valuation for Optis portfolio needed, because this portfolio is above average concerning the strength compared to other portfolios in the market. So you might not have so many patents, but the patents that you have in this portfolio are much better than the patents in the portfolio of others. So Optis basically argued that this meant that they should get something more than just the share calculated based on quantitative data here. The problem with that, in the eyes of the court, was, again, evidence. So the court found that evidence had not produced, or no credible evidence had been produced by Optis to support that the portfolio had been above average. And here the court also took into account the fact that Optis had withdrawn evidence from Mrs. Dwyer, which exactly also referred to this question of how many patents actually in the portfolio were essential. The court also said the outcome of the technical trials, where you had basically a broadly a 50-50 split so far in these proceedings, was also no indication of strength or quality. And the court also saw no, let's say, value in the argument that Optis had raised here, that when buying the patents that are included in its portfolio, it was particularly cautious. It bought patents from important SEP owners, which were, let's say, litigation grade patents, so particularly strong patents. The court said this could be something, of course, that would play a role, but Optis did not produce any evidence or any documentation regarding how they had selected the portfolio. So that, again, the court saw no real basis here to follow this argument. So that at the end of the day, it focused on the numbers, on the sole numbers. What was interesting and very important for the court was past infringement here, and how to deal with past infringement in the license. We have seen already that the court said that past sales, the past release, should be paid by April, and they should be paid on basis of the same lump sum amount per year as for future sales. So this is something which the court considered to be necessary here, but also more generally, the court said that the FRAND license should provide payment for past infringement, and the reason for that is to ensure that holdout does not pay. So the paying for the past sales would incentivize, without being punitive, the implementers to sign an agreement quickly, and therefore discourage holdout, because at the end of the day, and this is also a very important point, you would pay for this past uses, past infringements, with the equal value for the future, and you don't really get anything by delaying the proceeding, delaying the signing of a license, because you will pay for that at the end of the day. And an even greater incentive here would be to pay interest. The court found that this should be the case, that interest should be paid. It set up a provisional rate of 5% per year, payable on the 1st January of each year. It saw that this might be eventually too high, so this was just a provisional rate that might change. But definitely, what the court found that should be done in any case is that interest should be paid, irrespective of how high the rate would be. And having said that, the court also looked at the behavior of the parties in the negotiations, and tried to identify whether there had been holdup, on Optis' side or whether there had been holdout on Apple's side. A reason for that was that, according to the court, a large part of the case that each party made in these proceedings was basically accusations or allegations of hold-up or holdout. So on the one hand, Optis had argued that Apple did not negotiate in good faith, they were delaying, that they were basically saying something orally and the different something different when they were communicating per email. On the other hand, Apple had been arguing that Optis had acted abusively because it had started with an injunction, it had not provided a front price, etc. So a lot of the pleadings of the parties were around hold up and hold out, and the courts found that it should be the time here to set up something straight. So it started off by saying what is basically hold up and hold out, and if this is problematic, and it said that in principle, hold up and hold out are intrinsic to every hard commercial negotiation for a license, meaning that to a certain degree, hold up and hold out is to be expected as inevitable when you have licensing negotiations. Of course, both is undesirable because they do not lead to a swift conclusion of a license agreement. But the court said, in principle, hold up or hold out or trying to do the best of your position is not illegitimate or unlawful. Where it gets problematic is when you reach, let's say, the level of improper hold up or improper holdout or illegitimate hold up or legitimate holdout, because then this is no longer, let's say, something which is common to negotiations. So you get you go above that. So the court had some found that this can be something that is indeed so, that you can have improper hold up, improper holdout, going beyond what is usually done in negotiations. But it had the impression that to reach that, you have to overcome a very high threshold. And the court found that the closest analogy that you have here is an abuse of a market dominant position. So if you have been acting in a way which could be abusive in this sense, then you could speak about improper holdout or illegitimate holdup and holdout. But everything beyond that basically is relatively not problematic, or at least should not play a role in FRAND litigation. Accordingly, the court said that all the parties' pleadings in the proceedings and respective allegations were entirely irrelevant or a waste of valuable time and money, because neither party had argued that the counterparty had engaged in something that would be more than normal hold-up or hold-out or improper hold-up and hold-out. So all of these pleadings were, in the eyes of the court, considered irrelevant in the present case. All of the arguments of both parties that the other party did not engage in good faith, did delay, etc., were not found to be relevant. What was interesting here is that the court took the view that the UK case law has, in the meantime, created a legal regime which has resolved hold up and hold out. How is that? Hold up has been resolved because the patent owner cannot, let's say, threaten with an injunction, because he will not get an injunction when the infringer commits to take the court-determined FRAND terms. And how is holdout eliminated? It is eliminated because the license which the court is going to determine will ensure that past uses are fully paid, including interest. So the patent owner will not lose anything, will not lose money. And on the other hand, the implementer will pay everything he needed to pay, even if the license had been concluded at the very beginning. And what is interesting, maybe to keep in mind for future litigation, the court said, okay, the case law had not been really settled so far, so it is understandable to an extent that the parties try to argue with hold up and hold out in these proceedings. But since the case law now becomes settled, and we have the Unwired Planet Huawei case, we have the Interdigital decision a couple of months ago, and now this one, the court took the view that in the future there might be no justification to make similar arguments in UK FRAND proceedings. So this is something to keep in mind here. Having said that, the court also looked finally at this two questions of the parties' behavior here and how to deal with that. So the first question: did Apple engage in holdout? It said no, it did not engage in holdout. In the eyes of the court, Apple took a hard-nosed approach, meaning it had a hard way to negotiate, but it neither failed to engage nor operated in bad faith in the eyes of the court. What was interesting here is that the court reached this, although it found that several aspects of Apple's FRAND negotiation framework were indefensible and wrong, basically. This is, for example, the use of the SSPPU. The court said that the basic premise that you should use the profit of the chipset manufacturer to calculate the royalties is wrong in essence. And since you cannot assume that the chipset manufacturer will assume all the cost, the additional cost for the license. And then the court said if you would say that the license taken by the chipset manufacturer would exhaust rights downstream, then in any case, the FRAND price ought to be exactly the same as the price paid by the handset manufacturer, because then he is also freed from any burden to take a license. So using the SSPPU was seen by the court as indefensible. Also, the other argument that Apple had used, that you should basically exclude the additional value from inclusion of the technology in the standard from the SEP owner. So she should not get this value from the inclusion of the technology in the standard. Apple argued here that you should isolate each patent and make an assessment of its value before it was included in the standard. So individually, without looking at the value that the standard produces. But the court said also here this is not the way to go. SAPs are part of what makes the standard, so you cannot really say this is not something you should consider regarding the value of the standard and the value of the patents. And then the court also said declaring the patent and making the FRAND undertaking is also a contribution going beyond the value of the SEP itself. So this should be also mirrored in the licensing rates. And finally, the court also criticized Apple's insistence on having a patent by patent assessment of every patent included in portfolio on validity, essentiality, etc., because the answer was not difficult here. It found that this is simply unfeasible in the SEP context. And finally, the court also looked at whether Optis had acted in bad faith here, especially whether it had abused a market dominant position. That was the accusation of Apple, and it found that it was not the case. So it started by looking at whether that had been an abuse at all before looking whether there had been market dominance or not in the present case. And it basically said the contentions of Apple were pretty odd because there was no visible damage that that Apple has suffered due to Optis's behavior. It was not forced to take a license on an excessive price because it didn't take a license at all. It was not excluded by the market. There was no injunction, and it was not also inhibited in its other commercial activities. So there was no real element here to support that Apple suffered the damage by an abusive behavior. And also the litigation costs that Apple paid were not really a damage in this sense or not relevant here. Although Optis had made some missteps in the negotiations, the court found that they were not even close to an abusive behavior. In this context, one remark was interesting. The court said that in general, using competition law as a control over parties' negotiations, commercial negotiations, is a novel and remarkably dangerous contention. So here the court seems to be critical about basically looking at commercial negotiations and trying to police them with means of competition law. This is something which the court found should be very, very something that done very, very cautious and can be very dangerous. Looking at how parties negotiate and what is the leeway of that parties have in negotiations. And finally, just one final point, which is interesting. The court also, having found that there was no abuse, wanted to check whether Optis was at all a dominant undertaking in the present case, and it found that it was not. So the court said, of course, Optis has a market power, which derives from the combination of its intellectual property rights, which read on the standard, and the fact that the standard is broadly used in the market. But this market power does not grant a dominant position to Optis, because Optis is subject to the FRAND obligation, which means on the one hand that it is subject to a legally enforceable obligation to offer a license, and on the other hand, this means that Optis will not have access to an injunction when the implementer has expressed the willingness to obtain a license on FRAND terms and to commit to the license that the court is going to determine. So the court said here, Optis, even although it holds standard essential patents, it does not have a dominant position in this sense, in the competition law sense, which is also, I think, an interesting finding. So this has been all for today. I hope that you found the presentation interesting and have now a better understanding of the ruling. A summary of this decision and, of course, other court decisions which are related to standard essential patents are available at the case law section at 4IP Council's website. We always value your feedback, so please feel free to share any comments or suggestions on our platform through social media or per email at info@4ipcouncil.com. Thank you for listening and see you again next time.